Welcome to our LexisNexis podcast. I'm Tom Reed, a senior writer at LexisNexis and responsible for our practical guidance, insolvency and restructuring product. I'm joined today from LexisNexis by Michelle Wibisono, senior writer, practical guidance corporations. Hi, Michelle.
Hi, Tom. So you're going to take a look at the new debt restructuring process for small business for us.
Yeah, I thought it'd be interesting to walk through a scenario illustrating how the restructuring is likely to work in practice, see what's good, what might prove troublesome. Listeners can click on a link to a paper, which is an extract from our practical guidance, insolvency and restructuring product, which provides an outline of the restructuring process and sets out a more detailed treatment of the ground we're going to cover today, with all the references to the provisions of the Corporations Act and the regulations.
Great. So can you tell us what it's all about, Tom?
Well, as you know, Michelle, while most of us were on our summer holidays this year, we got a brand new form of insolvency administration, namely company restructuring. The provisions commenced operation on the 1st of January. And in terms of coming up to speed, the good news is that there is a lot about restructuring that's quite similar to voluntary administration. And I think the drafters of the new provisions have taken to the copy and paste function so that a lot of the framework, if you like, and much of the detail as well of the provisions which cover voluntary administration in Part 5.3a of the Corporations Act is replicated in the restructuring provisions in the new Part 5.3b. One somewhat unfortunate feature of the new provisions, which is, I think, a product of the way they came together in a hurry late last year, is that a lot of the important detail is contained in the regulations rather than the Act. So you do find yourself constantly jumping between the Act and the regulations, which is a bit awkward. And so one tip I would give to people is that if you're looking in the provisions for something, remember to look in both the Act and the regulations.
You've mentioned that there are similarities to administration, but what are the main differences?
Yeah, so there are two big differences. Firstly, this is only for companies with liabilities of $1 million or less. So many companies simply won't qualify. Secondly, this is a debtor in possession model, by which I mean the directors remain in control of the company throughout the process. So you don't have an insolvency practitioner stepping in to take control of the company. Instead, he or she sits a little to the side, although still very much involved, as we'll see.
So if I am an insolvent company with liabilities of less than $1 million, I have a new option now.
Correct, and one of several options, and it may or may not be the best one. But let's assume in this case, the directors of our hypothetical company have had some preliminary discussions about options with an experienced insolvency practitioner. And as an aside, I should say that those discussions would have needed to have been with a registered liquidator, as only registered liquidators can undertake the role of a small business restructuring practitioner, which is the name given to this new form of appointee. And it is worth noting that as a result of the reforms, we have a new category of registered liquidator, and they are only able to practice as small business restructuring practitioners and not other forms of external insolvency administration. But generally, I'd be saying to directors looking to make an appointment that they should start by speaking to an experienced insolvency lawyer or a trusted accountant to obtain an introduction to a suitable appointee. So again, let's assume the early advice is that restructuring looks to be the best option, and our directors have come to us, their lawyers, to understand what's involved.
You've mentioned that $1 million liability threshold earlier. Can you tell us what liabilities have to be counted in deciding if that threshold's met?
Yeah, so in assessing the liability threshold, it is important to drill down into the definition of liabilities, as it's not necessarily just a question of looking at the liabilities of the company as they appear on the balance sheet. The definition refers to a liability to pay an admissible debt or claim in relation to the restructuring, which is essentially a debt or claim as at the commencement of the restructuring, which would be admissible to proof if the company were wound up. And because the definition picks up what's provable in a winding up under section 5531, admissible claims include present claims, future claims, contingent claims, and claims sounding in damages. And I would note that people may have seen the draft legislation which was circulated in October last year, and contingent claims at that point were to be excluded from the liability definition, but they are now in fact included. So in applying the liabilities definition, for example, future liabilities under a lease would be included, and it would also appear that secured debt is also picked up by the definition. And then finally, employee entitlements are specifically excluded.
Right, so other than the $1 million liability threshold, can you tell us what other criteria companies must satisfy to access that restructuring regime?
The second matter that must be satisfied is that the company must not have used this restructuring process or the other new simplified liquidation process within the previous 7 years, and the same applies to directors or former directors of the company. But as the provisions have just commenced, generally this is not going to be an issue. I'd also be saying to our directors that if they're going to make an appointment, they will need to hold a board meeting to pass a resolution that there are reasonable grounds for suspecting that the company is insolvent or is likely to be insolvent at some future time. And they also need a resolution at the same time appointing a small business restructuring practitioner.
So besides meeting the $1 million liability threshold, ensuring that they're new to the restructuring or simplified liquidation process, and the board's passing the resolution that about the company's solvency, is there anything else you need to think about at this point, Tom?
There is. They need to be directors need to be comfortable that they're going to be able to satisfy some other legal and practical requirements which are ahead. Firstly, we'll need to warn our directors that employee entitlements need to be paid or substantially paid, and tax lodgements, although not payments, need to be up to date or substantially up to date by the time the proposed restructuring plan is sent out to creditors, which is going to happen within about 4 to 6 weeks after the appointment. And look, unfortunately, I think these requirements are going to effectively disqualify many small businesses from accessing the provisions. It's not unusual, for example, for a struggling small business to be behind on their tax lodgements, and at the very least on their superannuation contributions, which are included for these purposes in employee entitlements that have to be paid. Look, in fact, by the time many small businesses see their lawyers or accountants about their situation, many are regrettably completely destitute.
Presumably, small businesses that are in financial trouble are going to be cost conscious. What do you think we should be telling them about the costs of the process?
Yeah, Michelle, I think costs will definitely be an issue for many small businesses considering accessing the restructuring provisions. So we're talking mainly here about the costs of the restructuring practitioner, but the company might also have some legal costs, as well as, of course, the costs of ongoing trading. The fees of the restructuring practitioner differ depending on the phase of the restructuring process. Like voluntary administration, there's two main phases, if you like. Firstly, the period after the appointment while the company develops a restructuring plan and puts it to creditors for a vote. In this phase, the company is said to be under restructuring, which is the equivalent to being in administration and under the voluntary administration provisions. And then the second phase commences if and when the creditors accept a restructuring plan and runs until that plan has been carried into effect or otherwise ends. And this is the same or similar to the DOCA phase under Part 5.3a. Now, in that first phase, the fees of the restructuring practitioner have to be agreed and approved by the board and at a fixed amount before the restructuring commences. So this is a unique feature of restructuring, as normally hourly rates would apply for work on an insolvency administration. Now, there's an exception for legal proceedings where the company and the practitioner can agree on a method for determining remuneration, and I expect that that would normally be charge-out rates. And look, I think as lawyers, we're very familiar with the difficulties of estimating costs for anticipated work, and restructuring practitioners are going to face the same issues, except that they are going to be stuck with their fixed fee amounts. And so I think you might find some of them factoring in a high contingency component when a proposed restructuring looks like it could end up being complex or time consuming. But on the other hand, I think for the company, the certainty of knowing the fixed fees up front is certainly a good thing.
So we've let our clients know about the costs of the process. What else do you think we need to warn them about?
We need to tell them that within 5 days of the appointment, they're going to have to provide the restructuring practitioner with a declaration regarding the eligibility of the company to access the provisions. But also, potentially more problematic, is that they will also need to provide a declaration, or the same declaration is to provide that the company has not entered into a transaction that would be voidable under Section 588 FE of the Act, apart from preferences, in the event the company were wound up. Now, most directors are not familiar with the voidable transaction provisions, so some will no doubt ask their lawyers for advice about this, and at the very least they'll need to be given a summary of the voidable transaction provisions to know whether their declaration is properly based, or possibly they may need more complex advice if particular transactions need to be explored. So as we are beginning to see, while the explanatory memorandum for the new debt restructuring provisions told us that it would reduce complexity and cost compared to voluntary administration, even at this point in the process, it is already looking relatively complex for your average small business director.
Tom, do you expect the restructuring process to be widely utilised by eligible companies?
It's a good question, Michelle. I think only time will tell what sort of uptake there is. Look, it's quite possible that a large number of insolvent small business won't access the provisions due to the costs and complexity, or possibly the requirements for employee entitlements and tax lodgements to be up to date. And look, anecdotally, you do hear of many retail businesses having simply handed back their keys to their landlords. And the early statistics from ASIC appear to show that restructuring is off to a reasonably slow start. In the period to 25 February, ASIC is reporting only 3 notifications of restructuring appointment. And by comparison, in the last couple of years, on average, you get about 100 voluntary administrator appointments a month. But the number of appointments of restructuring practitioners, being 3 so far, isn't the whole story. Since the 1st of January, ASIC's website is also showing that 17 companies lodged declarations of eligibility for temporary restructuring relief, which indicate their intention to appoint a restructuring practitioner.
Tom, could you perhaps explain why companies would make a declaration of eligibility for temporary restructuring relief, as opposed to, simply starting the restructuring process?
Yeah, look, because there were concerns last year during the development of the legislation that companies might not be able to appoint a restructuring practitioner in the first few months of the operation of the provisions, either because there were not going to be enough insolvency practitioners to go around with the flood of willing applicants, or because the practitioners simply weren't ready to take appointments because They had to get across the new regime themselves. And because of those concerns, the legislation provided for companies to get a form of temporary relief while they were awaiting the appointment of a restructuring practitioner. And they could do that in the period to March this year. And the relief that is available, is the same that applied last year to all companies, which is namely that there's an increase of the threshold for statutory demands to $20,000 from $2,000. And the time to respond is to a statutory demand 6 months rather than 21 days. And further, the relief included, the temporary relief includes relief from the duty to prevent insolvency, insolvent trading. So to access that temporary restructuring relief by the 31st of March, directors have to make a declaration about the company's eligibility for temporary restructuring relief and publish a notice of the declaration on ASIC's published notices website and separately give a copy to ASIC. And then once eligible, the temporary relief applies for 3 months or a further month if the company is eligible to extend the period. So if you look at those stats, it is reasonable to assume that if these provisions are operating as they intended, that whilst there have only been 3 actual restructuring practitioner appointments, many, if not all of those 17 companies that have published notices in relation to temporary restructuring relief will end up in restructuring. I think the other thing to note at this point is that JobKeeper finishes in March, at the end of March, and at this stage the relief period for tenants of commercial tenancies that apply under the state and territory rules are also due to end around the same time, and those 2 things may see an increase in the number of companies commencing restructuring. I'd also add that the total number of external insolvency administration appointments is still well down this year compared to the same period last year. So it looks like it may take some time for the fallout from COVID to arrive.
Okay, so the directors understand the cost of the process, and they understand that they'll have to give a declaration to the restructuring practitioner about the company's eligibility for restructuring and that it hasn't entered into any voidable transactions. So then what's next for our directors who want to start the restructuring?
Yeah, so once the board resolution is passed, the company then needs to give a written appointment document, which is most likely an engagement letter, probably prepared by the practitioner, incorporating the required consent to act. And upon giving that written appointment document, the restructuring commences.
And once all that happens, the directors retain control of the company, as you've mentioned earlier, don't they?
They do, except that is if they want the company to enter a transaction affecting property of the company, which is not in the ordinary course of the company's business, in which case they will need to get the restructuring practitioner's consent or a court order. So, for example, they'd need consent for a significant asset sale.
Right, and you also mentioned earlier that in the period after the restructuring practitioner is appointed, the company develops a restructuring plan to be put to creditors for a vote. Could you tell us about that plan, how it's developed and what it might look like?
Yeah, so the key objective, of course, of the directors in this period is to develop a restructuring plan with the assistance of the restructuring practitioner. And to illustrate, a simple restructuring plan might involve a pool of money set aside for payment of creditors' debts and claims on a pro rata basis. So the pool could be funded from a third party, which is likely to be the directors or shareholders or someone associated with them. It could come from trading, from asset sales, or possibly a refinance. In terms of the form of the document itself, there is in fact an approved form of restructuring plan, and that's on ASIC's website. A restructuring plan is taken to include certain standard terms which are in the regulations, and which again there's a copy of those standard terms on ASIC's website. A plan may be subject to conditions which have to occur within 10 business days of creditors accepting the plan. For example, I think you'll see a lot of plans incorporating conditions which involve the agreement of the company's secured lender and or the landlord to new terms to deal with the post-restructuring period.
And how long does the company have to prepare a restructuring plan?
The company has 20 days from the appointment date to prepare and execute a plan, or it can get a 10 business day extension from the restructuring practitioner if there are reasonable grounds. This period is referred to in the Act as the proposal period.
Can we also discuss the restructuring practitioner that's been appointed? What's the role and duties of the restructuring practitioner in this period?
Yeah, so firstly, there's an initial notice sent out to creditors to let them know of the appointment and some details about the process. But again, the key role here of the practitioner is to assist the company to develop the restructuring plan. Now, in this period, during the restructuring, the company continues to trade, and it is important to note here that the restructuring practitioners are not personally liable for the debts incurred by the company during that period. I do think this is going to cause a few problems. If you look at voluntary administration, voluntary administrators are personally liable, and suppliers to the company take confidence from that in continuing to supply on usual terms. And I think well-informed suppliers alerted to the insolvent or near insolvent position of the company will, in the absence of the personal liability of the restructuring practitioner, be looking to impose cash on delivery terms. And this could present a real funding issue for the company if cash is tight, which is likely in many situations, I'd suggest. So by the end of the proposal period, which, as I've mentioned, is between 20 and 30 business days after commencement, the practitioner must send out a pack of documents to creditors incorporating 5 key things. Firstly, the proposed restructuring plan as executed by the company. Secondly, this restructuring plan standard terms. Thirdly, a restructuring proposal statement from the company. And again, there's a form available on ASIC's website. And this includes details about the plan and a list of all the creditors and their debts and claims. Fourthly, a declaration signed by the practitioner, principally regarding whether the company meets the eligibility criteria, whether it can discharge the plan obligations, and whether the restructuring proposal statement is complete. And finally, and importantly, a request to creditors to give a written statement as to whether the plan should be accepted, and also whether the creditor agrees or not with the company's assessment of their admissible debt or claim.
So the creditors, when they're given the restructuring plan, are they given any guidance about whether they should accept it?
Well, look, the Act and the regulations don't require that. And what creditors should really want to know is whether the restructuring plan is likely to result in a better return to them than a liquidation. In a voluntary administration, certainly creditors get a statement from the administrator as to what's in their interests. For example, proceed with a DOCA or alternatively put the company into liquidation. But that kind of recommendation isn't mandated here. Possibly a practice will develop where the company or the practitioner do in fact make a recommendation to creditors, but this does potentially seem to be a weakness in the process.
You've mentioned that the restructuring practitioner must ask the creditors to give a written statement that indicates whether or not they accept the restructuring plan, but I gather a meeting is not actually held.
That's right, no creditors meeting. So this is another unique feature of the restructuring process. And looking, in addition to giving the written statement to the practitioner about whether they accept the plan, the creditors are also asked to verify their debt or claim. If they believe it's not properly recorded in the information sent to them, then they have to give a notice to the practitioner within 5 business days.
5 business days, that's not very long, is it?
No, not long at all. So I would say to a lawyer, if you're a lawyer and one of your clients is a creditor of a company under restructuring and you get an email from them asking what's this restructuring thing all about, you might want to jump onto it quite quickly so that the creditor doesn't miss the deadline to potentially contest the assessment of their debt or claim. Now, if they do miss the deadline, they can give a notice later, but they have to give reasons at that time for the delay, and a restructuring practitioner might still refuse to consider the notice if he or she is satisfied that the creditor didn't take reasonable steps to give notice within the 5 business day period. The regulations provide for a process for determining such a dispute by creditors in relation to their debt or claim. That is, whether they dispute the amount, their status as an excluded creditor, which we'll come to, or if they're left off the list altogether. So this process ultimately involves a right to go to court, and it's really like the proof of debt procedures that apply in voluntary administration. Now, if as a result of the dispute process, the restructuring practitioner decides to vary the schedule of debts and claims, and is also of the opinion that the variation is significant, he or she has to give notice of that to creditors.
And how much time do creditors have to give their written statement indicating whether or not they accept the restructuring plan?
Creditors have 15 business days from the time that the restructuring plan and accompanying documents are sent to them to give their written statement. This is referred to as the acceptance period. It can be extended if there's a dispute with a creditor about the creditor's claim, as I mentioned, which leads to a significant variation in the schedule of debts or claims, and the period could also be extended by court order.
What about the voting threshold to get a plan through? Is it the same as the threshold for a deed of company arrangement?
It's slightly different. So in a voluntary administration on a poll, a resolution must be passed by a majority of creditors voting and a majority in value of creditors voting. So there are 2 limbs to the count, but under restructuring, to accept a restructuring plan, a majority by value of creditors who reply before the end of the acceptance period must be achieved. So that's a majority by value. So votes of excluded creditors are disregarded. So, for example, related entities. So if that majority is achieved, the plan is taken to have been made.
And that's when the under restructuring phase, the first phase in the restructuring process, will come to an end, isn't it?
Yeah, so that's the first way in which a restructuring can end. That is when a restructuring plan is made. Now, not all restructurings will end as happily as that. Firstly, a restructuring will end if the majority is not achieved. And also if the directors don't get to send a plan out at all within the proposal period, again, it all comes to an end. In addition, either the directors or the practitioner has a right to pull the pin, so to speak, and end the restructuring before the plan is sent out, and the directors don't need to satisfy any particular requirement to do so. The practitioner can terminate the restructuring or cancel a proposed plan, which has the same effect of ending the restructuring, but only in specified circumstances, which are broadly speaking aimed at protecting the interests of creditors. So, for example, if the practitioner discovers that the company doesn't meet the eligibility criteria, or it decides that it's really in the interests of creditors for the restructuring to end, the restructuring can be brought to an end. Finally, if there's an administrator or liquidator appointed, that also ends the restructuring, as does a court order.
What sort of period of time is the company looking at to get a restructuring plan approved?
Look, I would think around 7 to 9 weeks to get a plan approved, or longer if a creditor dispute drags the acceptance period out. So around 7 weeks if there's no extension to the proposal period, and say 9 weeks if there's a 2-week extension to the proposal period.
So now the under restructuring phase comes to an end, and you have the second phase in the restructuring process starting with the creditors having accepted the plan. What happens now?
Well, the directors remain in control, but now without the restrictions regarding transactions outside of the ordinary course of business. Normally, the insolvency practitioner who was the restructuring practitioner for the company automatically transitions to become the restructuring practitioner for the plan. His or her job is then to administer the plan, for example, holding the pool of money on trust and paying out creditors, or if requested by directors, selling specified property and distributing the proceeds. The plan will set out the restructuring practitioner's entitlement to remuneration, which in this phase of the process is a specified percentage of payments made to creditors, again, except for work in relation to legal proceedings. So this manner of calculation being the percentage of payments is also a new thing for insolvency practitioners. And once all the obligations under the plan have been fulfilled, the plan terminates and the company is released from all the admissible debts or claims. So the plan has, in this case, achieved its purpose as the company emerges from the burden of the unsustainable debt.
But I'm guessing that, like the restructuring phase, not all restructuring plans will end well.
Sadly, no, they won't. If a company, for example, contravenes the plan by, let's say, not making a contribution to the pool of monies, then if the contravention is not remedied within 30 business days, the restructuring plan terminates automatically, and any outstanding debts of claims under the plan are taken to be then due and payable. With a restructuring, in contrast to a voluntary administration, there's no automatic transition to liquidation, but the directors could then elect to place the company in voluntary liquidation, or a creditor might decide to seek to wind up the company. So I should say at this point that if there isn't anticipated or an actual contravention of the plan, and rectification might simply not be possible or likely to occur, then to avoid the plan from terminating, the company would have to go to court to apply for orders to, for example, vary the plan or some similar relief. And there's no provision here to go back to creditors to get them to approve a variation of the plan. So this is one element, I think, of restructuring, which is somewhat inflexible.
So overall, would you say restructuring is a good addition to our existing external administration regimes?
Yeah, I do. I think it's a good addition, not without its issues. Perhaps if we look at the positives first, first and foremost, it does offer the opportunity for a small company with a viable business but with unmanageable debt to enter the process and emerge at the end free from that debt and trade on, rather than, say, having to go into liquidation. As we've said, directors stay in control and they know their business best. And the layer of costs which result from an insolvency practitioner taking control is avoided. So while the company is under restructuring, it gets all of the breathing space, if you like, protections that also apply in voluntary administration. Court proceedings and enforcement proceedings are generally on hold. Restrictions on secured creditors, landlords and asset owners from exercising their property rights. Winding up applications are adjourned if the court is satisfied it's in the best interests of creditors. There's protection from third parties relying on ipso facto clauses, which need to refer to, for example, clauses which allow a party to terminate a contract because of an insolvency event. Not having meetings, I think, is a sensible aspect of the reforms. It's pretty quick, 7 to 9 weeks. It should be cheaper than voluntary administration. However, look, I think it does remain to be seen whether the differences are always going to be that significant. Another feature is that certain types of transactions entered into during restructuring can't be set aside in a later winding up, which does assist with dealing with third parties. And if I just put my director's hat on for a moment, once the company appoints a restructuring practitioner, I'm protected from insolvent trading liability and personal guarantees that I've signed or that my relatives may have signed can't be enforced while the company is under restructuring.
You've mentioned quite a few positives there, but what about the negatives?
Well, look, I think we've mentioned most of them already. Many companies won't qualify as their liabilities will exceed $1 million. Others will be behind in their tax lodgements or payments of their employee entitlements, so that will exclude them. I think the costs of the restructuring process is going to be a burden for cash-strapped small businesses. The lack of personal liability of restructuring practitioners that I mentioned could be a problem, leading to suppliers to impose COD terms. As with the deed of company arrangement and voluntary administration, of course, there's always a risk that creditors don't accept the plan. And many companies in that situation are just going to end up going into liquidation and having incurred costs and accumulated further losses. And again, as with any form of insolvency process, there's going to be damage to a company's reputation, the stigma associated with the company failure, and even after it exits the restructuring, the company is likely or may experience unwillingness of suppliers to extend credit, possibly difficulty in securing finance. From the perspective of the directors personally, again, if the restructuring fails, then their personal liabilities may increase due to the company having continued trading. For example, personal liabilities under guarantees, ATO director penalty notices, and any funding that they may have had to provide to support the ongoing trading and the costs of the process. So look, that's really about it. It's been a brisk walk through how restructuring is likely to play out. No doubt with a new set of laws, some difficult issues will arise from time to time because of the similarities with voluntary administration. Some of the case law developed over the years in applying those provisions will be readily applicable, or at least provide some guidance for restructuring. And perhaps finally, I should just also give a quick plug to our LexisNexis Practical Guidance product. As I mentioned at the beginning, you can click on the link to see most of what we've covered today. We have similar guidance covering other parts of restructuring, including a new set of restructuring precedents, as well as guidance for the broader insolvency topic and other practice areas. So thanks for joining me today, Michelle.
Thanks so much for taking us on that restructuring journey, Tom. Given all the issues that you've identified, I think it'll be really interesting to see how it all plays out. And I look forward to reading more about it in the Insolvency and Restructuring module.
Great. Thanks again, Michelle.